जब इंटरप्रिटेशन का सवाल आता है, इंटरप्रिटेशन इज ए टूल फॉर द जज टू चेंज द सोशल सिस्टम. 1856 में अमेरिकन सुप्रीम कोर्ट ने एक जजमेंट दिया जिसमें कहा कि निग्रोज आर नॉट द सिटीजन्स ऑफ दिस कंट्री. इट लेड टू सिविल वार. Abraham Lincoln was the president. He had to intervene. In 1863, 13th Amendment of the Constitution came. Negroes are the citizens. 14th Amendment in 1865, equal right, right to equality. What we have, Article 14, no arbitrariness, no discrimination. So it's a tool in the hand of a judge to change the social system. अब इसका उल्टा देखिए आप. Slavery was rampant throughout the world. There was no law prohibiting it. Queen Elizabeth I, who ruled from 1558 to 1603, is accused promoting slavery because they were getting huge money from the slave traders. In 1772, a person was captured from Africa, was taken to America. He was put in a cage, not given food for 3 days. Ship anchored in London, in Thames. He was crying for food. A lawyer was walking. So the lawyer asked him, "Why are you crying?" "Sir, I have not been served food for the last 4 days. I will die of starvation, hunger." He filed a writ petition, habeas corpus. He should be released. Now the question arose, is there any prohibition? Writ of habeas corpus lies if a person is detained illegally. So his lawyer submitted, there is no law prohibiting slavery. The Chief Justice asked, where is the law which permits slavery? See the contrary approach. Slavery is a crime against humanity. Therefore, show me the law. As there was no law permitting slavery, he issued the rule of habeas corpus and the person was released. So it's a question how to interpret, how to implement the law. Now Yagnvalkya put a decision, had said, every judgment of the king, every order, either in civil law or criminal law, if not based on reasons, yukti nahi hai, so it will amount to miscarriage of justice. Compare it today. Any judgment given by any court without reason is a nullity. Why it is so? Order 20, Rule 5 CPC, how to write a judgment, is a mandate for the judge. You must do all these things. And Rule 5 provides, give reasons. Order 41, Rule 31, every appellate court will deal with reasons. Your judgment should be duly supported by reasons. Section 354 CRPC, give reasons. So why the reason is necessary? So that the people may understand on what basis the case has been decided. In Sarojini Ramaswamy 1992, Supreme Court had gone beyond limits. They say if you don't give the reasons, you violate Article 21. Article 21 says no person can be deprived of life and liberty without following the procedure prescribed by law. Every order of a court adversely affects a party. When it adversely affects, either it affects his life or liberty. Therefore, not giving reasons violates Article 21 and it will not survive, it will be a nullity. We have now today the Legal Service Authority. Why? In 1934, Privy Council has to decide a case, Sitana versus Virana. There the question arose before the Privy Council, sir, our Gram Panchayat had decided this case. No issues were framed, no witness was examined, no written order was passed. They simply declared that this property does not belong to you and it belongs to your brother. What is the basis? Because the rules CPC, etc., which we follow in the court is not followed in Gram Panchayat. The Privy Council Madhyastha had been the means of solving the problems of the society from time immemorial. When a case is decided by large number of persons, there is no possibility of injustice. And all these formalities, whether the evidence was recorded or not, whether the cross-examination took place or not, are totally irrelevant, and they appreciate the working system of our Gram Panchayat. Munshi Premchand, this Jumman Sheikh, Algu Chaudhary, Panch Parmeshwar, nobody can doubt the impartiality of the Panch. In section 89, even CPC today provides that every court must think whether it is possible to solve this case by means of mediation, arbitration, ADR system before starting the case. In 16th century, Maharaja Banaras had to decide a case. It's a partition suit between the brothers, whose properties were involved. He was not able to solve it. When Maharaja failed to solve it, he requested Goswami Tulsidas. Goswami ji, you are the most respected person of the city. Why don't you decide this case? He called the members of the family and convinced them how the property should be partitioned. This is in the handwriting of Goswami Tulsidas. It is his award as a mediator, and it was accepted by all of them. But this system had been prevailing for a long time, and there is nothing in law today which cannot be solved with the help of our Vedic jurisprudence.